I mean, interim, Lordship.
CDS call for is not received, issue reminder, list the matter on.
50.
When do you want?
Short date में
Fourth of-
can be 4th of June. Oblige, man.
Interim order shall remain in force till then. 5050.
50.
Lordship, item 47, Lordship.
Oh.
I inquired, Lordship, the matter has been succeeded, Lordship.
Okay.
I'm on interim, Lordship.
Learned counsel, Mr.
J.M. Google, Lordship.
J.M. Gogoi is present for the petitioner. One petitioner.
One petition.
Learned petitioner PP, Mr. MP Gusam is present for the respondent state. It is submitted that charge sheet has been submitted against the petitioner being CS number.
30 of the 25, dated 34/25.
The petitioner is AB or BA?
AB, Lordship. I'm on-
Are you on interim bail?
Yes, Lordship, I'm on interim.
The petitioner is directed to appear before the jurisdictional court stroke Eraka magistrate within 20 days and apply for bail which may be considered by the court in accordance with law. Till then, no coercive action to be taken.
Obliged.
37, no?
47, Lordship.
Oh, 47.
My lord,
Obliged.
Yes.
item 1 may be adjourned.
Learned counsel, Mr. Aisha Chaudhary has prayed for adjournment. Please the matter when do you want?
Next week.
One, no?
Next one.
Mm.
Oblige. May I please, Your Lordship?
Oh,
Your Lordship, item number 24, Your Lordship. Maybe adjourned for the day, Your Lordship.
Learned counsel, Mr. Your name?
R.A. Muzumdar,
R.M. Muzumdar has
on behalf of IH Laskar.
on behalf of learned counsel, Mr. I.H.
Laskar,
Laskar, 20 what?
24, Your Lord.
Representing the petitioner has prayed for adjournment. Heard Mr. MP Usami, learned additional 50 Assam. List the matter when do you want?
After a week, Your Lord.
After 1 week.
Yes.
Date of the duration? 30 May.
Oblige.
Hmm.
May I please, Your Lordship?
Hmm.
Actually, victim is item number 40,
Hmm.
40. Maybe taken up in the next week, Lordship.
Learned counsel, Mr.
D. Chaudhary.
D. Chaudhary has prayed for adjournment. List the matter. Do you have the CD or NT?
This forest, I have
Okay,
informed them.
okay. 41, no?
40, 40.
List the matter 1 week of date of the duration, 28 May.
Interim order maker.
Interim order shall remain in force till the next date of listing.
Lordship, I beg to mention 41, item number 41.
Oh,
The CD was called for in the last appeal.
you have the CD? CD has called for is not received.
I mean, interim
List the
may be-
matter on. Interim order shall remain in force till then.
Obliged.
May I please, I beg to mention item number 18, my lord. Admission hearing, can you take up this matter at 2, my lord? Published.
May I please, Lordship, I beg to mention item number 19, Lordship. This matter may be fixed at 2. And Lordship, I have another appeal, Lordship.
18 and 19 both at 2, no?
No, not 19, Lordship, a 19. Sorry, Lordship, 19. 19 at 2,
Oh,
Lordship,
yes. No, 18 was the previous one.
different case.
Ah.
And Lordship, I have another appeal, Lordship. We have filed our objection in item number 50, 54, Lordship. Our objection may be called
Today?
today.
May I please, Your Lordship? Lordship, I beg to mention item number 52, Lordship.
Hmm.
That may be pass over for the day, Lordship.
Pass over for the day.
Lordship, we are on interim, Lordship. Interim.
Oh, date of the video. CD to be retained till 26 May.
Also, can it be on 23rd, Lordship?
Yes, can be 23rd.
Obliged, Lordship.
Lordship, item number 30, Lordship. Can be Lordship, day after tomorrow, Lordship.
Can be. Learned counsel, Mr. A.J. Ahmed has prayed for adjournment.
Yes.
Is the matter on day after tomorrow?
Yes,
Right?
Lordship. Lordship,
It was tight.
one period, Lordship, if the scan copy is received, may be taken. If, as per my instruction, it is already received, Lordship.
Okay, it is submitted that he has received, that the learned counsel has received instructions that scan copies have been forwarded. The full stop, if scan copies have been received, to tag the scan copies along with this case.
Yes, I'm okay.
May I please, Your Lordship? Lordship, I beg to mention item number 51, Lordship. Lordship, can it be taken up on next Monday, Lordship?
Can be.
26.
Learned counsel, Mr.
A. Brahma, Lordship.
M.
A. Brahma.
A. Bromo has prayed for adjournment. Is the matter on?
Lordship, we are on interim, Lordship.
Interim order shall remain in force till then. Do you have the CD? Huh? CD to be retained till 26 May.
51.
May I please, your lordship?
Yes,
I
yes.
beg to mention item number 37, my lord. This matter by possible for the day, my lord.
Okay.
As an interim order, my lord. As there
Learned
has been
Learned
any date,
counsel
madam,
Mr.
next week.
Bora has paid for adjournment. List the matter on. CD is received.
So there are 27.
CD is received. CD to be retained till
There is an interim order, madam, that may be continued.
interim order shall remain in force till 28 May.
May I please, your lordship?
Yes.
My lord, I beg to mention item number 13, lordship. 1-3, lordship. Lordship, this matter may be listed before appropriate bench, lordship, because another co-accused already considered by the another coordinate bench of this honorable court.
Learned counsel Mr.
N.H. Borhuya, lordship.
And
On behalf of
on
R.D.
behalf of learned counsel Mr.
R.D. Gupta, lordship.
R.D. Gupta has submitted that একটু একেবারে check করে sound দেখুন that he has submitted that the co-accused
Yes, lordship.
of this case arising out of the same cause of action has been granted bail by another bench.
Annexer 1 is that order, lordship.
Okay, but that bench is in Guwahati.
That perhaps not, lordship. Honorable Justice Thakuria, lordship.
Oh no, then it will come up here. It will come up here
Lordship.
because she's not in. She's in Nagaland. That's why.
Yes, yes, lordship. That's why perhaps, lordship. Then, lordship, your lordship, this matter will be taken up on next Monday, lordship.
Learned counsel Namkini has paid for adjournment. Do you have the CD?
Motion stage.
Oh, motion matter. Okay. List the matter on. May, please.
Oblige.
May I please, Lord?
Oh.
Lordship, I beg to mention item number 49, Lord.
Oh.
Lordship, in this case, charge sheet has been filed and consequently PRC case number already numbered, Lordship, but I have could not collect the charge sheet number.
The sheet file, madam, with the number.
Acha.
You want to continue here or you want to?
And
Huh?
we like to surrender, Lordship.
Or you want to surrender? Okay. Learned counsel, Mr. Item number
Item
49.
49.
80 Sarkar has submitted that charge sheet has been laid in connection with this case. Learned additional PP Mr. MP Gusami has submitted that charge sheet has been laid in this case being CS number.
269/24, dated 28/8/24.
The petitioner is at liberty to approach the jurisdiction court stroke Alaka magistrate and apply for bail which may be considered by the court in accordance with law.
May please, Your Lordship. It's a
Mm.
regular bail application, Your Lordship.
Mm.
The petitioner is behind the bar for last more than 208 days, Your Lordship. It's a simple case of love story, Your Lordship, behind victim and boy. As alleged that the victim has been victim is under the age of 18 years. Though this honorable court has earlier occasion granted bail, considering the city, but subsequently since POSCO Act has been POSCO section has been ended. London trial court has been rejected a bail application. Thereafter, their trial has been proceeded, and we have
Now
annexed
POSCO.
My lord,
POSCO is ended.
is
So
appeared,
what
madam,
is
but
going on and on?
He is
response number has appeared, madam, but
we took steps upon the.
she has not received, madam. And copy not received.
But thing is that we have annexed the victim statement and the
Victim statement. Where
yes,
is the
I have
victim
annexed.
Statement.
yes, annexer L.
We'll call for the scan copies. NDPS.
NDPS, madam, but
NDPS.
not LCR, madam, because she has not submitted.
Okay, okay.
So case diary.
Call for the case diary. List the matter on which thana?
From Nilam Bazar.
Nilam Bazar PS.
Nilam Bazar, 2
Same.
weeks.
Same
We did
only
2
district.
weeks. 2 weeks time ta did. 2nd June.
My lord, last week of. Okay, madam. God bless.
May it please your lordship, my lord, NDPS not from conscious position. My lord, 47 notice not given, only reasons for arrest and my lord, arrest memo has been provided.
Charge sheet has been submitted.
No, my lord,
Charge sheet not
that has.
CD then?
My lord,
Which thana?
my lord, it will
From
be
South Salmon.
South Salmana, Mankacha.
Even been like 2nd June. 2nd June.
That's 72 days.
Call for a CD. List the matter on 2nd June.
Official document. No, you don't.
No, please, your lordship. This is a regular bail application, lordship. The FIR is in page 11. The relevant portion is page 15. So this FIR has been filed, but I have not named in this FIR. And lordship, similarly, accused persons have been granted by your lordship already.
What is the offense alleged?
This is the taking bribe. I'm a police officer or an tip received from my LC branch.
So charge sheet has been submitted.
No, Lordship.
We'll call for a CD then.
Lordship.
Call for the CD, okay. Yes, yes.
Lordship, CD may be
Call for a
confirmed.
CD, list the matter on 3rd of June,
No, Lordship. After 10.
huh?
After 10.
After 10 June.
Yes.
11 June.
Lordship. Deep.
My presentation. Commercial quantity lordship. Lordship trial case lordship call for
Call for
LCR.
the scan copies of the trial court record along with the scan copies of
Lordship
the
short
CD.
date may be
Is
given
the
lordship.
matter on? Yes, yes, short date.
Who
Short date are detailed.
accused already released
Okay,
bail.
okay, short date. 29th of May.
Okay.
Right, please. Yeah, my lord, 2.47 grams of my lord heroin was recovered from the present petitioners, my lord. Yeah, my lord, 2.4 small quantity.
Small quantity.
Small quantity. My lord, this honorable court in various judgment, my lord, held that my lord, small quantity as a my lord available in nature.
No.
It cannot be met because
Not bailable offense.
not available, madam.
Also, my lord, one judgment was my lord passed by my lord honorable justice M. Japan Khama, my lord. It was held that my lord, it's available in nature, my lord, and another judgment, my lord, by my lord honorable justice my lord Kolita, my lord. It was held as a small quantity, my lord.
Held a small quantity.
A small quantity is available in nature, my lord.
Okay.
It's available in nature, my lord.
No,
May I, my
maybe bailable.
may
I don't know. Let me see the judgment.
Lordship, my lord. Really, my lord, I have-
Opinion, madam.
Hmm?
In the coordinate bench also said that it's non-available, madam.
Which bench?
My lord justice, Aquarium, my lord. Because it itself says that it is a non-constitutional offense.
Yeah, my lord, in
Then
honorable
you
justice,
give me
my
the
lord,
judgment.
in honorable justice, my lord Kolita, my lord, it was.
How
my
many
lord-
days you are behind bars?
I'm behind the bar, my lord, since last, my lord, 14 days, my lord.
Section.
Since last 14 days, my lord, I'm in by my lord.
Considering, my lord, small quantity, latest short date
quantity
may be
and
given, my lord, without going. my lord.
2.47, my lord, grams from
My lord.
two petitioner, my lord. 2.47 grams, my lord. So my period of detention may also be considered, my lord, because
It's okay, no? Small quantity, are you sure?
Yes,
Point-
yes, 2 point is small quantity because
yes, ma'am. 5 grams, up to 5 grams is small, my lord.
5 to 250 is in between, my
In
lord.
Third
So a
line,
small-
Counsel Mr. K.
a-
Borwa
Okay, bro.
for the petitioner. Oh, three. How many petitioners?
Two petitioner. my lord.
For the petitioners, 1, 2, Namgirali Kiriba, who have filed this application under section 483 of the BNWS 2023. Okay, I don't want to observe anything,
Lordship, my lord.
only length of detention.
Lordship.
No length, my lord.
Hmm.
Only, my lord, I am praying for the city. That is,
It's okay, maybe there are differences of opinions. In
yes,
case
because
it is held to be bailable, then it will be,
that
it
is-
will be violation of human rights then.
Yes, because my lord, that court says, my lord, section 37 equal lordship is, my lord.
No, that we
Yeah,
keep
I'm
on
not going to
reading
that.
over and over again. There
I'm-
is nothing that it is
I'm
bailable.
not going to, my lord.
All the offenses are non-bailable,
Non-bailable.
it's written, non-cognizable,
Not cognizant.
yes,
Cognizant.
cognizable and
Cognizable.
non-bailable, it's written there.
It's written there. So it can.
But that is the act, but there are views, no?
And there are-
So in case somewhere it is supposing held, there are judgments of the Supreme Court also holding that it's not
non-bailable.
bailable.
Non-
So only considering the quantity, my lord, 2.47 from two petitioners, my lord.
No, that cannot be the sole ground, but without going into the bailable arena, let's, any other ground you have, good ground,
Lordship, my lord, period of detention, my lord.
and any other ground, period of detention, and any other.
Rest, my lord. But alleged recovery is there, my lord. So, my lord, I basically praise on my lord that judgment, my lord. I'm considering my period of detention, my lord, 14 days, my lord, for
See,
2.47 grams.
conflicting judgment he also has of Justice Mitali Korea.
Therefore, my lord, since my period of detention and my considering my age, my lord,
How old are you?
35 and 38, my lord.
This is this age cannot be considered. You are neither a young lad nor a old person. Okay, Burra, for the petitioners, so and so who have filed this application under section 483 of the BNWS 2023 with prayer for bail as they have been arrested in connection with so-and-so PS case under so-and-so sections. Had Mr. MP Gusami Learned Edition PP Assam. The petitioners have prayed for bail on the prayed for bail, stating that they will cooperate with the remaining part of the investigation and will not jump the bail if they are released on bail. I have considered the submissions at the learned additional PP has raised objections stating that 2.7 grams,
2.47.
2.47 grams of heroin was found in conscious possession of the petitioners. It is further submitted that Section 35 of the NDPS Act clearly denotes that all offences under the NDPS Act are bailable, non-bailable and cognizable. Okay,
Yes, ma'am.
only this much I
Here,
will
here.
quote.
Section 37.
I have considered the submissions at the bar with circumspection. I have considered the submission that the petitioners are willing to cooperate with the remaining part of the investigation. The petitioners were apprehended while they were in possession of small quantity of heroin. The petitioners are local residents and are not flight risks. Considering all aspects, both the petitioners are enlarged on bail of rupees 50,000 each with a suitable surety of like amount to the satisfaction of the
SGGM M. Gusai.
under the condition that the petitioner shall refrain from such activities with which they are alleged, the petitioner shall appear before the IO on every fortnight till completion of investigation, and the petitioner shall not leave the jurisdiction of the court without prior permission. On breach of any of the bail conditions, bail order shall, the court is at liberty to immediately cancel the bail granted to the petitioners.
And Lordship has
Acknowledgement.
shown sympathy because they file for information, whether they will inform or not. That is up to them.
The number of cases shows where they reform, there is any reformation of not increasing day by day.
Yeah.
Acknowledge.
Yeah, please, Your Honor. Case is registered under NDPS Act. Under section 22C, 25, 25(9) of the NDPS Act, my lord.
CD or
CD, ma'am.
CD.
CD.
Investigation.
Commercial
CD.
file.
Call for the CD, list the matter on from which Thana?
Nagaon, sir.
10 দিন মানৰ ডেট দি দিলে যাব 3rd of June, okay?
Highlight.
May I please? My lord, application under section 483 of BNSS, my lord.
POSCO.
No, my lord, NDPS, my lord. In this case, my lord, co-accused has already been granted bail, my lord.
So we'll call for the scan copies of the CD. Lordship.
Scan copy already available in connection with BA number 170 of 2020. So let the matter be listed along with 170, my lord.
BA number
170, my lord.
okay. Call for the 170.
Yes, my lord. Page 2, my
Call for
lord.
the scan copies of the trial court record along with the scan copies of the CD. List the matter on when?
No, no, 22, my lord.
Along with
Along with BA number
BA number?
170.
No, we'll have to give a date.
There, BA number 20. 170/2025.
When is the next date piece of that case?
5/5/2025.
5/5/2000.
Dispose of, my lord. Dispose of. Bail
Okay.
granted, my lord.
So when do you want?
On 22, my lord. Matter is available.
Along with Nalage. Dispose of matter cannot be along with to Nalage Katidia, release the matter on data diopson on 26 May. Okay.
Wait, please, Your Lord.
Mm.
But it's the regular bail, my lord. But I am seeking bail on the ground, my lord, page 54, my lord. Non-furnishing of the ground to the, my
We'll
lord.
have to call for the charge sheet submitted.
Yes, my lord, charge sheet
Call for
submitted.
the scan copies of the trial court record along with the scan copies of the CD, list the matter on.
From Guwahati itself, my lord. My. 28 তারিখ কি বার?
May I please, Lordship?
Lordship, here it is a case, Lordship, where the petitioners were behind the bar, Lordship, last 6 years, 6 months, Lordship.
I know, but we'll have to get their
No,
copies.
absolutely, Lordship, but fix a short date.
Sure.
And they will have to also file their objection because it's a DRI matter, Lordship, I know. They will also file their objection.
Okay, you'll file your objection?
Lordship.
Learned counsel, Mr.
Is that, Ahmed?
A.Z. Ahmed is present for the petitioners, one petitioner,
Yes,
petitioner and learned counsel, Miss.
And Kakoti Lordship.
And Kakoti is present for the, on behalf of Mr. S.C.K.
Sika Lordship.
Comma standing counsel of DRI and has submitted that they will file, that DRI will file objection against the bail petition. Call for the scanned copies of the trial court record along with the scanned copies of the CD, list the matter of for LCR and the objection. Okay, you file your objection, 6 years,
yes, Lordship, the 27, Lordship. 27.
27.
Yes. Thank you.
Oh, bless Lordship.
May I please, your Lordship?
Yes, please.
Intermediate quantity, Lordship, kindly a long date, Lordship.
Long date.
Look.
Why?
Because only, Lordship, 18 days, only 18 days.
Yes,
Not a-
long date.
not undertaking,
Call
Lordship.
for the CD,
CD.
list the matter of.
15 month হবে না? No, 15, 16. Lordship. Much obliged, your Lordship. Much obliged, much.
Please, your Lordship. Lordship, the accused person was arrested on 28th of October, 2023. And the
NDPS, no?
Yes, Lordship, NDPS.
Charge sheet has been submitted.
Lordship submitted, but Lordship kindly go to page number 2.
We'll call for this, we'll hear you. We'll hear you elaborately.
It is not amount to commercial, I think, your Lordship, page number 12.
That, for that, we have to find out that we'll need the CD
Page
or
number,
the trial court records. At least to find out that, we'll have to find out your submission. Call for the scanned copies of the trial court record along with the scanned copies of the CD, list the matter on. When do you want?
so that maybe
Short day, 28?
28, okay.
Please, your Lordship. But in this criminal reputation, we are seeking quashing of a criminal proceeding arising out of a complaint petition instituted in Panipat, Haryana, under 138 NI Act, and also in the order taking cognizance. Now, it is judicially settled, my lord, that complaint can be quashed in exercise of power under 226. There is no gray area. But here, admittedly, complaint was filed in Panipat, Haryana, and cognizance was taken there at Panipat. So the first, my lord, and question and just address this court, whether this court has the territorial jurisdiction to entertain this petition. My lord, may kindly take this Constitution 226.
Constitution from আসেনি here. Hello, what is it? लोगों लिखे ভিতরে
98.
ভিতরে লোগো আছে ও দেখিস এই এটা দেখো Yes, 226.
Wait, is this 226-2? Kindly peruse 226-2. May I read?
Just a moment. Yes.
I'm reading 226-2. The power conferred by clause 1 to issue directions, orders, or writ to any government authority or person may also be exercised by any high court exercising jurisdiction in relating to the territories within which the cause of action arises. Very important. Cause of action arises wholly or in part for exercise of such power, notwithstanding that the seat of such government or authority or the residence of such person is not within those territories. So it says if cause of action wholly or partly arises within the jurisdiction of one high court, that the high court has the jurisdiction to entertain it, notwithstanding the authority or person who issued it is outside the territories of this high court. So in order to show that 226(2) applies, I have to show to this court that cause of action even partly arises within the jurisdiction of this honorable court. Now, there are 5 constituents of the offense under 138 NI Act.
And I can give. And I can give.
It's a settled law. It was laid down in K. Vaskaran and followed by numerous subsequent decisions. 5 constituents, my lord. 1 is the drawal of the check. Second is the presentation of the check. Second is the dishonor. 4th is the statutory demand notice. And 5th is non-payment within 15 days of the receipt of notice. So these 5. If we go by the generic definition of the term cause of action, each of these facts will constitute a part of cause of action. Now, admitted position is that check was drawn on a bank at Guwahati, presented at Panipat, dishonored at Guwahati, and this statutory notice was presumed to be received at Guwahati. So admittedly, some of the cause of action arises within the jurisdiction of the honorable court. So my first submission is that this court absolutely has the jurisdiction to entertain this petition. And in support of that, I'm just relying a decision of our high court, our own high court. It reported in 2014 3 GLJ 32. Also arising out of a 138 proceeding, that matter. Kindly see para 6, 7, and 8. 6. There is no dispute to the proposition that an FIR or a complaint can be challenged in a petition under 482 CRPC or by filing a petition under Article 226 of the Constitution. Since the present petition has been filed under Article 226 of the Constitution of India, we may briefly dilate the broad parameters for invoking the writ jurisdiction. Para 7. Article 226(1) of the Constitution of India provides that every High Court shall have the power throughout the territories in relation to which it exercises jurisdiction to issue to any person or authority, including any government, within those territories direction, order, or writ for enforcement of any of the right conferred by Part 3 of the Constitution of India or any other purpose. Sub-Article 2, however, clarifies that a power conferred by Clause 1 to issue direction, order, or writs to any government authority or person may also be exercised by any high court exercising jurisdiction in relation to the territories within which the cause of action wholly or in part arises for the exercise of such power, notwithstanding that the seat of such government or authority or residence of such person is not within those territories. Para 8, I'm also reading it, para 8. In other words, the High Court would have jurisdiction to issue direction, order, or writ to any government, authority, or person which may be outside its territorial jurisdiction, if the cause of action or part of it arises within its territorial jurisdiction. This aspect of the matter has been elaborately explained by the Honorable Supreme Court in case of so and so. Now kindly come to page para 10 at page 6, second last page. Para 10.
Okay.
If perusal of the complaint would show that the orders for the goods were placed at Guwahati, the check issued were also of Guwahati. If the amendments made in the repetition are accepted as correct, which in any case have gone unrebutted, since there is no denial of the respondent, then a large number of events which led to the filing of the complaint at Aligarh, that is in UP, my lord, had taken place at Guwahati. Thus, it can be said that if not the whole, at least a part of the cause of action arose within the territorial jurisdiction of this court, and therefore this court would have territorial jurisdiction to entertain the present writ petition.
Yes.
So here, my lord, this check was drawn at Guwahati, rejected at Guwahati, and also presumed to be served the statutory notice at Guwahati. So undoubtedly, some of the cause of action arises within the territorial jurisdiction of Guwahati. So this court has absolute jurisdiction to entertain this petition. So far as this is, my lord, regarding maintainability. Now, the ground was challenged, my lord. The ladyship may kindly appreciate that it is the non-payment of this check amount within 15 days of receipt of notice will only confer, my lord, cause of action to the complainant to lay a complaint petition. 15 days from receipt of notice. Now, admittedly here, the case of the complainant is that notice was sent to me and it was unserved, returned back with the postal endorsement, insufficient address. Admitted case.
Mm.
Kindly see this page 26. That
You
is
are,
the
you are
para
seeking interim stay,
interim stay.
but this is a NI case.
Maybe, but I'm just trying to impress upon your ladyship that there is no cause of action.
This case, that case was quashed. But there
Yes,
is nothing of nothing relating to interim stay granted.
it depends on the case to case, my lord. I'm not pressing this in support of my interim prayer. I'm supporting this judgment only to show that this court has the territorial jurisdiction to entertain this petition. Now I'm on stay. I'm just trying to show, my lord, that even to presume under 27, there must be
You want the
amendment
complaint case to be stayed.
at least for the returnable
What is
date,
the
my lord.
check amount?
At least for the returnable date, my lord. At least for the returnable
What is
date.
the check amount?
11 lakhs. 11 lakhs 14,026.
Okay, can I suggest that let the LCR come, then after going through the LCR, we can pass an order?
So my lord, I'm praying for an interim order because according to me, my lord, there is no cause of action. And despite that, I have to
But-
move to, my lord,
There is,
Haryana.
but there has been transactions, business transactions.
There are business transactions. I'm not on this, my lord, the ground of challenge. I am only going by that whatever they have stated in the complaint petition is a gospel truth. All I'm trying to, my lord, articulate that even to draw presumption under section 27, General Clauses Act,
I understand.
it should be on proper address.
Maybe you have a good case for quashing, but
Proper address, my lord.
I will not wait for the return of notice. We'll just wait for the LCR. LCR will be nothing but a complaint petition, but even then,
Yes, my lord, because
Okay.
complaint, I have annexed the complaint
we'll
petition along with
wait,
this, my lord.
wait for the return of notice to
Well-
pass any interim order, only for the LCR.
Well, I have, my lord, annexed this complaint petition. It's part of the record. I'm just trying to show from their complaint where they have stated that it was addressed to the correct address. Only then you draw presumption under section 27. There is no such averments, not a passing whisper. That is a must. It's a sine qua non, my lord, to invoke presumption under section 27. So all I'm saying, my lord, let notice go, at least till returnable that I'm can be protected. Because I have to travel to Haryana, my lord, to face the trial from Guwahati, even though apparently there is no cause of action. Because non-payment, even after
You are a
receipt of
lady, woman.
my lord, lady.
Okay, let's go to the complaint petition then.
Yes. And you see, my lord, page 26, my lord.
How old are you?
I am affidavit case as well. No. Lady got given birth. Affidavit case as well. Around 46 years.
Okay.
Can you come to page, my lord? 26, para 7. Can you see para 7, my lord? The complaint got served the legal notice dated so-and-so through his counsel so-and-so, which was sent to the accused through registered AD. By way of said notice, the accused called upon so-and-so to pay so-and-so to the complaint within a period of 15 days from the date of receipt of the said notice. The accused intentionally and willfully avoided receipt of the said registered AD post containing legal notice. And the same has been received back on so-and-so with the report of insufficient address. However, the accused has failed to make the payment of the check amount to the complainant till today. Therefore, the accused has committed offense under 138. Kindly consider this postal endorsement. It is not that address is left, not found, premises closed. Only then we can say I am avoiding. Yet says insufficient address. It never came to me.
What is the transaction between the two of you?
Look, what happened here, my lord? I was running a distributorship of dairy products. This complainant is a manufacturer of desi ghee. So some of their representatives come to Guwahati there and they appointed me as their distributors. They sent some consignment of ghees to sell it to the retailers. Some of them subsequently returned back, complaining inferior quality. Their case is that for the remaining of this ghee, my lord, this check was drawn. Our case is that it was issued as a security matter. I'm not on that. It is a matter of trial. All I'm trying to show, my lord, today, at this stage, that even going by their complaint, no cause of action accrues to the complainant. Because non-receipt, non-payment of this check amount within 15 days of receipt of this demand notice only give them a cause of action to institute this. Can you see this? Even this, my lord, the cognizance order, page 39. See this order.
Do you have the reply of notice?
No, we didn't receive it, madam.
Oh, you didn't receive
We didn't
it.
receive it, madam.
So you didn't reply?
No knowledge, madam. No knowledge. That's my case. Can you see this page 39 order, madam? Last page, madam. Para 3. This is an order by which cognizance was taken and process was issued. Can you see hard Para 3, hard perusal of the document placed on record reveals that the complainant has presented the check within the period of validity. Thereafter, complainant issued a legal notice to the accused within a period of 30 days from the date of receipt of the communication about the fact of the dishonor of check. Accused failed to make payment of the complainant within stipulated time. Keeping in view of the above, there is a sufficient prima facie ground to proceed against the accused under 138. But where is that I have received it, or even presumption? That is a must, that is a sine qua non. Only then offense will be committed, and that will give them a cause of action to lay this complaint petition. Even this cognizance order might not proceed on the premises that even giving of notice will give them a cause of action. K. Bhaskaran is very clear. There, a distinction was drawn between giving of notice and receipt of notice. Giving is an act, receipt is the accomplishment. Legislation clearly make a distinction. It says non-payment within 15 days of receipt of this notice. There is no receipt. Even the cognizance order didn't show that, madam. It merely says notice was issued, I didn't pay, and therefore cognizance was issued, taken.
I'll pass an order. I'll have to ponder over it. I'll
Yes,
go
yes.
through the entire records. I'll ponder over it. I'll pass an order.
Yes, yes.
Because Haryana also will call for record where, in what manner it will come, how it will come. I also don't know.
At this stage, my prayer.
Records will definitely not call. We'll call for scan copies only.
Yes, yes. So
Let's
only,
see. I'll
only
pass
for
an
a
order.
limited prayer, my lord, till returnable day. That's all my prayer. Kindly consider this. Consider this.
So got an order to divorce us.
Item 17. Before item 17, I'm sorry, my lord, in item number 8, my lord. Recently, I came to know that case record has been transferred to my lord Special Judge Pokrajhar, my lord. Direction was given to my lord Gosaigaon, ADGM Gosaigaon, my lord. So instead of my lord ADGM Gosaigaon, it should be my lord. Item 8, direction may be given to disposal of matter. Item direction may be given. Take it.
Please, your lordship. Well, there is an application for clearance bail. The FI, your lordship will get at page 18. It starts at, my lord, page 13. The relevant page,
Page 50.
page 18, my lord.
This is the first day it has been
Let me,
come on board.
let me place my facts, my lord. Thereafter, your lordship will.
It's okay.
The sections are, my lord, section 61 sub 2 of BNS, criminal conspiracy, and the element of under PC Act 7, 9, 10, and 12. He is not a, my lord, name accused, and he doesn't have any connection. I'll show, my lord. May I read the FIR again, my lord?
Yes, yes.
Source information has revealed that Sri Prayas Chakraborty, Deputy General Manager, Oil India Limited, Dulijan, Assam, in connivance with Sri Jyoti Kumar Singh, DGM Sales and Marketing, Messrs. United Drilling Tools Limited, Noida, and unknown public servants are indulging in corrupt and illegal activities of obtaining bribe money against facilities, facilitating the issuance of award of work and clearance of bills of the said private contractor supplier, thereby causing huge wrongful gains to themselves and corresponding wrongful loss to the union, etc. Source information has further revealed that on 16/4/2025, Sri Prayas Chakraborty again demanded 17 grams of gold ornaments for himself as well as for some other unknown public servants from Sri Jyoti Kumar Singh against award of certain contract in favor of him, and Jyoti Kumar Singh also agreed to the demand. Source information also reveals that on 18/4/2025, Sri Jyoti Kumar Singh conveyed to Sri Prayas Chakraborty that he had taken the approval of his managing director, Sri Kunal Gupta, for a bribe amount of rupees 7 lakhs. Sri Prayat Chakraborty reminded him that he had not asked for cash and once again demanded delivery of 70 grams of gold coins instead. Sri Jyoti Kumar Singh told him that due to some reason, he wouldn't be able to purchase gold and therefore he would deliver rupees 7 lakh in cash instead. Source information exists that on 3/5/2025 evening, Sri Jyoti Kumar Singh would be delivering certain cash amount as bribe instead of gold to Sri Prayas Chakraborty near Sector 61 Noida, which is also close to the residence of Prayas Chakraborty at Noida. The above mentioned act of public servant and private persons discloses the commission of cognizable offence under 61(2) BNS and section 7, 9, 10, 12 of the PCA, and hence a regular case is registered. Now, my lord, Sri Prayas Chakraborty, he has been, my lord, arrested in the meantime. The petitioner is not, my lord, mentioned anywhere. He's also, my lord, not a supplier. He doesn't have any connection with the Oil India Limited. Now, what happened, my lord, on the next day itself, this FIR was lodged on 3rd of May.
Yes.
On 4th of May, my lord, the CBI searched, my lord, his house, he and his father's house. His father is a businessman, my lord. If your lordship kindly comes to page 23, my lord. Page 23, your lordship will find the details of property seized by police. Page 23, my lord.
Yes.
Serial number 3, date and hour of search, 7:20 p.m. to 9:20 p.m. of 4/5/2025. FIR was on 3rd, my lord. Then, my lord, name and address of the person whose house is searched, industrial trade and agencies, office premises, so-and-so, and his, my lord, residence. Now, my lord, this, my lord, the industrial trade and agencies, my lord, that stands in the name of the father. So, my lord, he is also residing there. Then your lordship will come, my lord, come to the next page, the things which are, my lord, seized. Page 24, your lordship will find, my lord, serial number 1, file GM tender number so-and-so. One tender file was seized from the custody of the father. Another file, serial number 2. Then, my lord, your lordship will get the details of the property seized by the police officer that at page 27. Page 27, your lordship, if your lordship comes to the second chart, my lord, that is the description of the article seized. Column number 2, one invoice dated 34/2025 of rupees 10,300 issued by Messrs. Sokhani Jewellery. This is, my lord, recovered seized from the bedroom of the petitioner. One, my lord, invoice of rupees 10,300. This is the, my lord, only thing that was seized. And my lord, page 2, page 28, my lord, one mobile phone. These are the only 2 things seized. But then, my lord, your lordship may also come to page 29, second paragraph. During search proceedings, may I read it, my lord?
Yes.
During search proceedings, cash of rupees 3.50 lakhs was found from the bedroom of residential premises of Sri Pradip Kasera. Pradip Kasera is the father of the petitioner, my lord, which were handed over to Sri Pradip Kasera during the search proceeding. And one invoice dated 34/2025 for rupees 10,300. So, my lord, rupees 3.5 lakhs was found from the custody of the father. That was also returned to him. So, my lord, in spite of all this, my lord, the petitioner is, the CBI is, my lord, calling him at different point of some, asking for the, my lord, at some point on time, the, my lord, the other card or some documents. And he is also, my lord, he had a very serious accident earlier, my lord, and he's also under medical treatment. That document, of course, my lord, I could not produce at that relevant point of time. May I place it, my lord? No. Now, my lord, so far as the father is concerned, my lord, he has already been granted by bail by this honorable court. My lord, that order also I am placing, my lord. Look on the- So nothing was found in their residential houses. And the, my lord, father of the petitioner in whose name, my lord, the business stands. He has already been granted interim protection, my lord, by this honorable court. And the next date is fixed on 28th of May. So my prayer would be, my lord, your lordship will kindly protect the petitioner till that date and connect both the matters together, my.
It is at the initial stage, the investigation is still going on. So at this stage, if they will be given some protection, there is every likelihood that the document may be manufactured or the evidence may be tampered with.
They have already searched the house, my lord, they have found nothing.
But it is a very initial stage, your house.
And he is also not named in
And
the,
I
my
need
lord.
to file some objection. I will have to get the instruction at what stage and what is the development in this case.
My lord, they are, my lord, harassing the petitioner and asking
There
for,
is as such no
my lord,
harassment.
making the recording of statements, my lord. I'll go there. Whatever condition your lordship will impose, but the, my lord, same protection that was given to.
Can she file an objection within a short period of time and then we will consider?
No, my lord, that is fine, my lord. But then, my lord, the father, who is a businessman, my lord, who doing business with the,
What does this petitioner do?
he's a young man, my lord. He does some, my lord, small business.
Father is already protected. In fact, they are supposed to cooperate with the investigating.
We'll cooperate, my lord. We'll cooperate. The same
So at
conditions,
this
my lord.
stage-
In fact,
What-
harsh conditions have
He
been.
met with an accident?
My
Yes,
lord?
met with an accident.
He's met with an
He met with
accident.
a very serious accident, my lord. He had broken his skull. He was in coma for a very long time. Now also he cannot travel also. He has been advised not to travel. So, my lord, in fact, this in the interim order that has been granted to the father, my lord, that imposes serious, my lord, strong conditions. There's some conditions may be imposed, my lord, till the next day, till they file their objection. In the meantime, my lord, he'll appear whenever they want. Because he's a resident of Tinsukia, my lord, and they are investigating from Dibrugarh.
No, from Delhi branch, it is AC2.
You have mentioned it in the petition about his accident?
Yes, my lord. That on ailment, my lord. About the accident, I have not mentioned, my
not
lord.
mentioned.
That we
Not
asked
mentioned.
subsequent. We didn't
It is
mention.
not
Got the
mentioned.
reports.
No medical.
Because we
It is
got the
subsequent
report now.
development. Maybe it is of long back. Or attendant.
Whenever they want, my lord, he'll appear. And that is the condition, so far as his father is also concerned, my lord. Next date is very close by. Till that time, your lordship will kindly protect me. (28/5) is the next date, my lord. Today is 19. Let them come with whatever objection they have, my lord. In the meantime, if they want to interrogate me, my lord, I'll go there. That also your lordship may make it clear, my lord.
Admittedly, his name is not appearing, so no protection is required at this stage. I don't know why they have come with this application.
We have not come for fun, my lord. We have got apprehensions, that's why we have come. Otherwise, why should he take the trouble, my lord? His father was earlier disturbed, my lord. Now he is being disturbed again. He says, come to
Even his father's name is
come to
also not
Dibrugarh, bring your dad document.
in
these
the
documents.
FIR. In fact, they are not supposed to file any AV. I don't know.
That
why
is
they
all
have
the
come.
more reason, my
But
lord,
in
why.
fact, being a citizen, they are supposed
But
to
see,
cooperate.
this medical report is from Guwahati.
Yes, my lord.
So
Yes.
he is traveling, no?
Yes, he is traveling, my lord, because for treatment he has to come, my lord. He had all entire, my lord, skull broken. Although that was a long time ago, but he's still, my lord, under treatment. In fact, my lord, his father was hospitalized and that's why he had to come. Hospitalized at Guwahati, he had to accompany his father and then also had this checkup.
I'll pass an order later. I'll ponder over it. I'll pass an order later.
Because, my lord, 28th is the next date, my lord. Father, 28th is the next date fixed for his father's case, my lord. He has been
Date to
protected.
next date to liquidate also.
The copy of the order I have already given.
Oh, Lilo. I'll pass an order later. I'll ponder over it. I'll pass an order later. Much up. Hey, really? Oil or CBI.
Me, please, Your Lordship. 483 bail application, Your Lordship. Petitioner behind the bars for about 3 or 4 months, 17 days now.
Okay.
I'm sorry, madam.
Mm.
My lord, the petitioner was arrested on 1/1/2022. Today is about 3 years, 4 months, 17 days. His mainly in this case mainly arrest from accused Vikram Deswal and from Iftikhar Ali, the contrabands were recovered, madam. Lordship will final complaint at page number 15. So thereafter their statement were recorded, and on the basis of the statement, Lordship, subsequently he was arrested, Lordship. From his position, from this Jasvinder Singh, the present position, from his position, nothing recovered, Lordship. His house was also searched at that point of time, and the seizing officer examined by the prosecution, Lordship, and then in his deposition, he has not stated that anything recovered from his position as well as from the house at the time of search. So he is inside the jail for about 3 years, 4 months, 17 days. Charged them, total number of witnesses were Lordship 9, and 4 witnesses examined till today, including the seizing officer, madam. Last witness since 2022 October 2024 till today, no witnesses additional by them. Lordship produced before this court, before the client court. Lordship passed the order in favor of the accused Iftar Ali at page number 69. His involvement only on the basis of the 67 statement, Lordship.
Yes.
Lordship, it cannot be denied that the involvement was not there. Involvement was there, Lordship, because there was he was in frequent contact with Vikram Jaiswal, from whom the Lordship contraband was recovered. And Lordship, there was a transaction of huge amount with Vikram Jaiswal, from whom the contraband was recovered. So Lordship, it cannot be denied. Involvement was there, Lordship. And regarding, yes, Lordship, 4 witnesses have been examined out of 9. And Lordship, the present status is, Lordship, one of the co-accused got bail from this honorable court. He is found absent. Court is passing order for issuing NBW against him, Lordship. Clearly reflected, mentioned in the order of 15/5/25, Lordship. Maybe he has jumped the bail, Lordship.
Maybe.
So this is the status, Lordship. And Lordship, we have filed our objection, Lordship. Our objection may be considered, and I am placing one judgment, Lordship. I have marked, Lordship. My judgment may be considered, Lordship.
What is the contraband?
Contraband is
Methamphetamine, Lordship.
methamphetamine tablet.
967 gram methamphetamine.
From, it is recovered from other accused, lordship. From Ikhtar Ali and Bikram Jaiswal. And my lord, in this case, the compliance of the section 50 is also not there. The notice is there, lordship, it is recorded now. Yes, sir. Section 50 notice, lordship, issued, but without any grounds, lordship. And 50A is also not there, lordship.
Any other ground?
Any other ground, lordship, I would like to place this pollute levy to in this regard, lordship. And other lordship regarding the this situation, Muhammad Muslim. I will give it.
Palula, which paragraph?
Paragraph 12, lordship. Tufan Singh referred in this case, lordship. May I read, lordship?
Not required.
And lordship, I would like to Rabi Prakash. Rabi Prakash.
All right, then I'm granting bail. Give me.
I'm giving.
Submission should be recorded.
Yes, it will be recorded. Our learned counsel, Ms. S.K. Nargis, for the petitioner, Jasvinder Singh, and learned counsel, Ms. M. Deka, on behalf of learned standing counsel, Mr. S.K. representing the NCB. It is submitted on behalf of the petitioner that he was arrested on 1/1/2022, and he has been behind bars for 3 months, 4 days, and 3 years, 4 months, and 17 days. Full stop. 4 out of 9 witnesses have been examined. Full stop. Trial has been procrastinated, infringing the right of personal liberty of the petitioner. It is submitted that one seizing officer was examined as PW what? Who has not supported the seizure, PW4, who has not supported the seizure of the contraband. It is further submitted that the contraband was not recovered from the possession of the petitioner, but from the co-accused. Full stop. The petitioner has been forwarded to custody on the statement of the co-accused. Full stop. The learned counsel for the petitioner has relied on the decision of the Honorable Supreme Court in Palula bin Ahmed, Arimutta, and another versus State by NCB Bengaluru, State by NCB versus Palula bin Ahmed, Arimutta, and another, and other petitioners and respondents reported in 2022 12 SCC 633, wherein it has been observed that para 12 to good লিখিব The petitioner has also relied on the decision of the Honorable Supreme Court in Ravi Mohammed Muslim. No.
Rabi Prakash. Rabi Prakash.
Where is Ravi Prakash? Ravi Prakash Nai. No. This is Mohammed Muslims. Nalagi. The learned counsel for the respondent has raised serious objection. Next.
Rabi Prakash we have.
Par contra, the learned counsel for the respondent has raised serious objection, stating that the petitioner is booked under a heinous offense. To stop the involvement of the petitioner cannot be ruled out. The petitioner was in constant touch with the co-accused Bikram Jaiswal.
From whom lordship contraband was
From
recovered.
whom the
Bikram Jaiswal and Asif.
It is submitted that the contraband.
Iftikhar Ali.
It's okay. It is submitted that the contraband is 967 grams of methamphetamine.
Tablets.
Methamphetamine.
Yes.
Tablets. Juliet budget is telling you. So if the petitioner is enlarged on bail, he will be a threat to the society as large, as it appears that the petitioner will continue with his business of drug peddling. PEDDLING. It is further submitted that the conduct of the co-accused is relevant to this case. Full stop. One co-accused was granted bail, but now at this juncture, the case record reveals that the co-accused has not appeared before the trial court, procrastinating the trial. Full stop. It is the petitioner's co-accused who has procrastinated the trial and not the court or the prosecution. Full stop. And the court was impelled to issue NBWA against the co-accused. Full stop. In reply, the learned counsel for the petitioner has submitted that the petitioner has been highly prejudiced as Section 50 notice issued to the petitioner clearly reflects that the grounds of arrest were not communicated to the petitioner in a manner understood by the petitioner. Full stop. Moreover, Section 50A notices were not issued to the relatives of the petitioner. The petitioner has also relied on the decision of the Honorable Supreme Court in Ravi Prakash versus the state of Odisha. Can I quote live law citation?
SLP number maybe.
Yes. And in connection with SLP criminal 4169 of 2023, where by order dated 13/7/2023, it was observed that para 4. The learned, on the contrary, the learned additional 50 to Polula to Likila, no? It's okay. No more judgment is required. I'll send it back, okay?
Yes.
I find force in the argument of the learned counsel for the petitioner. It appears that I have also scrutinized the trial court records. It appears that the grounds of arrest have not been communicated to the petitioner in a manner understood by the petitioner, nor were the grounds of arrest communicated to the relatives of the petitioner. It appears that bail may be granted to the petitioner. The petitioner can enlarge on bail of rupees 1 lakh with a suitable security apply amount to the satisfaction of the learned trial court under the condition that the petitioner shall not leave the jurisdiction of the court till completion of trial. The petitioner shall refrain from such activities with which he is alleged, and the petitioner shall not exercise threats to witnesses or try to influence them. On breach of any of the bail conditions, the court is at liberty to immediately cancel the bail granted to the petitioner. ইয়াতে দুটা judgment আছে, তিনটা আছে, ইয়াতে চাই ল'ব। মোক কৈ দিছোঁ পেৰাখিনি, একো দিগদাৰ নহয়। ঠিকে আছে নে? নোট কৰিব পাৰিলে। Item 21.
May it please your lordship. Lordship, this is the regular bail application filed by the petitioner who is behind the bar for 329 days. Lordship, during the time of the filing of the bail petition, I could not annex the ground of arrest notice, Lordship. I would like to produce it. It's a certified copy. There was no mention of any grounds regarding the grounds of arrest.
What is the contraband? No, this is not certified copy. You
Is it
file an affidavit or a certified copy later. This is not, this is Xerox copy.
No, this is, I am furnishing the Xerox copy, your lordship.
No. Otherwise, he can, have you mentioned it in your petition?
No.
Oh, that is not mentioned in the petition. As it was not
Then
available with me.
You add it along with the copy. We may not require a copy, we have the LCR, but without mentioning in the petition, you cannot submit according to the High Court rules. If you want, you can add it. I can give you adjournment for today.
Okay, the case may be fixed in the
Learned
next week.
counsel, yeah, sure. Learned counsel, Miss
Ebora.
Ebora has prayed for adjournment. Is the matter next to the deed? This is their photocopy, not their photocopy.
Much obliged.
Yes, given it.
May I please, your lordship? My lord, the petitioner is behind the bar for 44 days, my lord.
What is the offense?
Offense, my lord, under section
6
to
kg 900
80.
grams of ganja recovered from the
6 kg 900
You have
gram
the
of
CD?
ganja. Intermediate
CD
quantity,
received.
my lord.
Okay, then you can't bail them.
Only considering the length of detention, 44 days.
Third learned counsel, Mr.
H.A. Ahmed.
H.A. Ahmed for the petitioner. Mountu Talukdar, who has filed his application under section 483 of the BNWS 2023 with prayer for bail as is behind bars since 5/4/2025 in connection with so-and-so PS case under so-and-so sections. But Mr. P. Botago, learned additional PP Assam. I have considered the submissions at the bar with circumspection. The learned additional PP has submitted that they are incriminating materials in the case diary against the petitioner. The petitioner was apprehended while he was in possession of how many grams of
6
ganja?
kg 900 gram.
6 kg 900 6 kg 9 kgs 900 grams of ganja. So I have also considered the submission that the petitioner is willing to cooperate with the remaining part of the investigation. Full stop. Considering all aspects, the petitioner is enlarged on bail of rupees 50,000 with a suitable surety of like amount to the satisfaction of the learned trial court under the condition that the petitioner shall refrain from such activities with which is alleged. Number 2, the petitioner shall not leave the jurisdiction of the court without prior permission till completion of trial, and the petitioner shall not try to exercise threats to witnesses or influence them. On breach of any of the bail conditions, the court is at liberty to immediately cancel the bail granted to the petitioner, send back the seal.
Hello.
May I please, your lordship? The lordship 483 bail application, 26 kilograms of NDPS was recovered from 4 people, your lordship.
26 kilograms of what?
Oh, yeah, ganja was recovered, your lordship, from 4 persons. Three of them
Don't
have,
divide it now.
3 of them have already
How many
granted
bail
bail.
days you are behind bars?
Your lordship, 1 year and 9 months, and out of the 4 accused, 3 of them have been granted bail, your lordship. I've added the bail orders in page number 32 and 41, and moreover, your lordship,
Out of how many accused?
out of 4, 3 have been granted bail, your lordship. And I'm not the active person from whom the substance was recovered. I was only present in the house where the contraband was hidden, your lordship. And the reason of bail in all the 3 orders is with regards to the section 50 notice, your lordship. And we have also taken the plea of parity, your lordship.
Have you checked this section 50?
Yes, but it's not wrong. I have
Not mentioned.
No.
Grounds of arrest not communicated.
seen.
Third learned counsel, Mr.
Tohid Laskar, your lordship. He Laskar.
E. Loskar for the petitioner. Jugesa Das, who has filed his application under section 483 of the BNWS 2023 with prayer for bail as is behind bars since 16/7/2023 in connection with so-and-so PS case under so-and-so sections. Third, Mr. MP Guswami learned additional PP Assam. It is submitted on behalf of the petitioner that the petitioner was not in conscious possession of the ganja. Full stop. It is further submitted that the petitioner is entitled to bail as all the 3 co-accused have been enlarged on bail in connection with this case. It is further submitted that grounds of arrest were not communicated to the petitioner in a manner understood by the petitioner. The notice under section 50 CRPC clearly reveals the violation of the statutory mandate. So it is submitted that the petitioner's right to personal liberty has been curtailed. Third learned additional PP, Mr.
Page 34, my lord, my submission is earlier case, my
Huh?
page 34, my lord. Maybe paragraph 7 and 8.
Mr. MP Goswami, who has raised serious objection, stating that four witnesses have already been examined, because of the trial is progressing at a good pace, and though there is no undue delay in the present case.
Same case, we are not taking the same case.
It is further submitted that the Honorable Supreme Court has
Lord, I'm just pointing out. Lord.
It is further submitted that the petitioner is booked under a heinous offense of transporting how many kgs of ganja?
Not transporting yourself, only
No,
in
it's
possession.
okay.
26 kgs of.
It's okay. How many kgs of ganja? 26.
26
kgs of ganja. I have considered the submissions at the bar with circumspection. I have also considered the submission that the grounds of arrest were not communicated to the petitioner in a manner understood by the petitioner. It appears that bail may be granted to the petitioner. The petitioner is hereby enlarged on bail of rupees 1 lakh with a suitable surety of like amount to the satisfaction of the learned trial court, under the condition that the petitioner shall not leave the jurisdiction of the court till completion of trial. The petitioner shall refrain from such activities with which is alleged, and the petitioner shall not exercise threats to the witnesses or try to influence them on breach of any of the bail conditions. The court is at liberty to immediately cancel the bail granted to the petitioner.
Much obliged. Sir.
Intermediate quantity lordship 51 days behind the bar. Lordship. Other custodial detention might not be.
How many days? 51.
51 days lordship.
Okay,
50
you
grams
have
of
the CD?
7.1 gram of heroin, my lord, net weight. Otherwise, you know, there are materials against the accused persons.
Mr. S. Munir for the petitioner, দুজন আছে, চাইলবা নাম কিটা লিখি দিবা. Petitioners who have filed this application under section 483 of the BNWS 2023 with prayer for bail, as they are behind bars since 29/3/2025 in connection with so and so PS case under so and so sections. Are Mr. P. Bothago, learned additional CP, Assam. It is submitted on behalf of the petitioner that petitioners that the petitioners are willing to cooperate with the remaining part of the investigation. They have already been behind bars for 51 days, no?
Today 51 days.
51 days, full stop. The learned additional PP has raised objections stating that they are incriminating materials in the case diary against the petitioners. They have been apprehended while transporting 7 point how many grams?
7.1 gram net weight.
7.1 grams of net weight of heroin. Full stop. I have considered the submissions at the bar with circumspection. I have considered the submission that the petitioners are willing to cooperate with the remaining part of the investigation. Full stop. The petitioners are local residents and they are not flight risks, RISKs. Considering all aspects, both the petitioners are enlarged on bail of rupees 50,000 each with a suitable surety of like amount to the immediate agot dia jinkita condition ase. Trial do nalage, ha? Trial no, etu trial no hai.
Satisfaction of lordship special just Nalbari lot. In bracket NDPS will be. Much obliged, Lord.
Till completion of trial nalage shall not leave the jurisdiction of the court. One can deal with to CD as a two. Send back the CD likhi.
Much obliged.
May I please, Your Lordship? Yes, Mr. Lordship. This is a charge sheeted case of NDPS under section 20C and 29 of the NDPS Act for 21 kgs of ganja. And I am behind the bar for as of today 506 days. And there are 9 number of witnesses, among which only 3 has been examined so far. And they being the independent witnesses did not supported the prosecution case. And they have deposed in their deposition, admitted in their deposition that they had connection with the police officials and they had previously appeared in many cases. And now I am before this court on the strength of non-mentioning of the grounds of arrest, Lordship, in the arrest memo as well as section 50 CRPC. I have marked the same in the scan copy, Lordship. Section 50 notice, there is no grounds mentioned in there. And I being the code, as alleged in the FI, I being the co-driver, I have no connection with the, no knowledge that contraband was being carried on there. I am not even the owner of the car.
Co-passenger, driver?
Co-driver. Not driver, as passenger. It was a Tata Sumo car.
Both the persons are present, madam. Each Dinanath Yadav, madam, he is also present while the recovery was made, madam, from vehicle. So she is very much in conscious possession of the contraband. Other thing, madam, they will find, madam, 3 witnesses already over. Okay, okay. 37 commercial party.
Our learned counsel, Miss
L. Banik.
L. Banik for the petitioner, as on a Dinanath Yadav, who has filed his application under section 483 of the BNWF 2050 with prayer for bail, as is behind bars of 506 days in connection with NDPS case number 16 of 2024, arising out of so-and-so PS case under so-and-so sections. It is submitted that 3 out of 9 witnesses have been examined, but not a single witness has supported the prosecution case. It is submitted that the grounds of arrest were also not communicated to the petitioner. The annexure, which is the annexure E.
Yes.
And annexure?
Annexure E at page number 30.
And where is the 50
Section 50 notice I have not annexed it. It is there in the scan copy.
Okay, it is further submitted that the annexure E is the arrest memo, which clearly reflects that the grounds of arrest were not mentioned in the arrest memo or in the notice under section 50 CRPC. Next prayer, Lika per contra, the learned additional 50, Mr. MP Guswami has raised serious objections stating that the petitioner was present in the Tata Sumo vehicle, which was transporting commercial quantity of ganja, full stop. It is further submitted that 3 witnesses have already been examined and the case was proceeding at a regular pace. It is further submitted that, what was the other submission?
I think commercial quantity.
Yes, that I have noted down. I have considered the submissions at the bar with circumspection. It is true that the grounds of arrest were not communicated to the petitioner in a manner understood by the petitioner. It appears that bail may be granted to the petitioner. Considering all aspects, the petitioner is enlarged on bail of rupees 1 lakh with a suitable surety of like amount to the satisfaction of the learned trial court under the condition that the petitioner shall cooperate with the trial. The number 2, the petitioner shall not jump the bail. Okay, I'm not giving that condition to be present in the court.
Yeah,
because he's from Calcutta.
West Bengal, yes.
1 lakh with 2 local sureties of like amount. So I've changed the sureties. 2 local sureties of like amount. Bail of rupees 1 lakh. The petitioner shall not exercise third condition, and the petitioner shall not exercise threats to the witnesses or try to influence them. On breach of any of the bail conditions, the court is at liberty to immediately cancel the bail granted to the petitioner.
Maybe your comment here. One maybe comment.
Comment is very difficult. Who is getting salary 1 lakh per month? Who is getting salary 1 lakh per month? It's difficult, you'll have to produce a magistrate
Yeah. Yeah.
as government security
Yes,
or
my lord,
Oil India
because
officer, officer from oil or from ONGC.
Even then, my lord,
They are disappearing, yes.
they are disappearing because of that.
Where you get? You'll have to produce a officer from ONGC or oil.
27, my lord, this matter may kindly taken up on my day after tomorrow.
Day after tomorrow, okay.
We'll have to do
Day after tomorrow.
Lordship, actually, reason I don't know, the city has received.
Thursday, my lord. I will have to get some instruction.
Okay.
Lordship,
Learned
city has
additional
received, I have come on the grounds of arrest, Lordship, where my was fundamental rights is violated. That's why I have come to the case,
Yes.
Lordship.
Everybody's fundamental rights are violated.
Lordship.
Transporting.
But CD has been received.
900
What instruction is
grams of
there to
Java
be?
tablets, fundamental rights are violated.
Yes.
CD is received, Lordship.
Learned additional PP, Mr. P. Bodakur has prayed for adjournment on him. I'm putting the
Only to
blame on
get
him.
some instruction regarding
Has
my lord,
prayed
grounds
for
of arrest.
adjournment, to obtain instruction relating to the grounds of arrest communicated to the petitioner, list the matter on 22nd May.
This matter may kindly be taken up at 2, my lord.
Please, Your Lordship. Madam, there is a recent development in this case. The accused petitioner has been convicted now. So to ascertain that fact, my lord, this matter may be fixed for a short date so that we can
Okay.
ascertain the fact.
Learned counsel, Mr. ABC, has prayed for adjournment to obtain instructions.
No, my lord. In this case, scan copy not yet received. 29, my lord. Scan copy.
Meanwhile, also call for the scan copies of the trial.
POSCO is there, my
court.
lord. POSCO is there.
Okay. Along with the scan copies of the CD, please the matter on.
Value.
Met please, Lordship. Lordship, this is an application under section 483, Lordship. Petitioner was arrested on 19/4, Lordship.
Do you have the CD or the LCR or anything?
LCR is related.
31 CD received.
Okay. Yes.
Lordship, FIR at page 14, Lordship. Allegation is that 2 persons have been arrested on 17/4/2025, Lordship, along with 200 kg of suspected to be beef, Lordship. Those persons are arrested on
31.
On 17/4, Lordship, and thereafter, Lordship, those 2 persons were remanded police custody, Lordship. And on the basis of interrogation and their statement, Lordship, I have been arrested on 19/4 from the residence of my
When
father-in-law.
were you arrested?
19/4, Lordship, page 19 is the forwarding letter.
19/4, okay.
19/4/2000. Nothing was recovered from me, Lordship. And I am behind the bar since last 31 days, Lordship.
You have the CD?
Yes, my lord. Case diary received, my lord. Item number 31 and 33, my lord. Same PS case, my lord. In item number 33, there are 2 petitioners.
32 DDS. P25, what is the punishment?
My lord,
Bailable.
Bailable.
Yes.
Not 325 BNS not available.
Only the length of punishment, length of imprisonment.
325 is bailable.
325 is not available.
Okay. They are behind bars for sufficient period of time.
Yes, ma'am.
There are materials in the CD?
Yes, materials there in the case diary, my lord, from the possession of the my lord Sahalom Ali, item number 23, and my lord Rabu Bakkar Siddiqui, my lord, those my lord 200 kg of beef were recovered, and thereafter on the basis of their statement, the present petitioner in item number 31 was arrested, my lord, and both these accused persons were involved in committing this type of offense, my lord, since long, my lord.
But here in your lordship, we are in custody.
I'm granting it. Our learned counsel, Mr.
I am R. Islam, lordship.
R.S.
R. Islam.
R. Islam for the petitioner, as on petitioner, who
Right.
has filed his application under section 483 with prayer for bail as is behind bars since 2025 in connection with so-and-so PS case under so-and-so sections. The allegation against the petitioner is that he was involved in smuggling beef weighing 200 kgs. Heard Mr. P. Botagu learned additional PP Assam, who has stated that the incriminating materials in the case diary against the petitioner. It is submitted on behalf of the petitioner that the petitioner is innocent and he has not been named in the FIR. So it is submitted that he has been brought to custody on the basis of the statement of the co-accused. Full stop. I have considered the submissions at the bar with circumspection. I have considered the submission that the petitioner is willing to cooperate with the remaining part of the investigation. Full stop. It is submitted that the petitioner is a local resident and he is not a flight risk. Considering all aspects, the petitioner is enlarged on bail of rupees 30,000 with a suitable surety of like amount to the satisfaction of the learned
SDGM Gosaigaon.
under the condition that the petitioner shall refrain from such activities with which he is alleged. The petitioner shall not leave the jurisdiction of the court without prior permission. The petitioner shall appear before the IO on every fortnight till completion of investigation.
Lordship,
Which of any of
may I only point out, Lordship, I am a local resident in West Bengal, Lordship.
Oh, to কাটি দিয়ে লাষ্টৰ এইটো কাটি দিয়ে without permission to কাটি দিয়ে আৰু he is not a flight risk to এইটো কাটি
Obliged.
local surety লিখি দিব Heard Mr.
AM Khanir.
AM Khan learned counsel for the petitioners দুজন আছে storyখিনি একে আছে from smuggling beef বাকিখিনি একে আছে what is your submission ground
My submission is, your lordship, basically we are for 33 days is in custody, your lordship.
the petitioner has paid for bail on the ground that he further custodial detention is not required for the progress of investigation. I find force in the argument of the learned counsel for the petitioner. বাকিখিনি একে লিখি দিবা
Obliged.
send back the CD দুইটাতে লিখি দিবা
32 MP Goswami has gone through the LCR after some time.
Basically, lordship, the ground of arrest lordship. It's a commercial quantity lordship. LCR also received, but basically.
why let him come why you want it now
No.
Lordship, this is under section 303 and 317, Lordship. He is behind the bar since last 59 days, Lordship.
you have the CD
Yes, ma'am. Case they received.
where is the FIR
FIR is at case 12, Lordship.
do you have any objection
Lordship,
Yes,
this
my lord, total he is my lord involved. Otherwise, he is driver of one
he is
Subhas
driver,
Das, my lord.
Lordship.
page 12
And Subhas Das
Culture.
not yet arrested, my lord. From him. Those petroleum.
what is the allegation
Allegation is that, Lordship, they were carrying 20 jerrycans of petroleum products, crude oil. But he is the driver of the tempo, Lordship. He is not involved. Actually, he had parked his
Pardon,
tempo.
Miss what is your name
S.E. Ahmed.
S
E. Ahmed.
Ahmed, Miss S. Ahmed, learned counsel for the petitioner. Rupam Kolta, who has filed his application under section 483 of the BNWS 2023 with prayer for bail as is behind bars since 21/3/2025 in connection with so-and-so PS case under so-and-so sections. The allegation against the petitioner is that he was transporting 20 gallons, each containing 4 liters of
400,
petroleum
40 liters.
of 4 liters, not 40 liters.
40 liters.
40 liters of petroleum product is submitted on behalf of the petitioner that the petitioner is not involved in this case. Full stop. He has been forwarded to custody on suspicion as he was the driver of the vehicle apprehended in connection with this case bearing registration number AS01NC2614. The learned additional PP, Mr. P. Botagur has raised serious objections stating that there are incriminating materials in the case diary against the petitioner. I have considered the submissions at the bar with circumspection. I have considered it appears that custodial detention may not be required to further the investigation. I have also considered the length of detention. I have considered the submission that the petitioner is willing to cooperate with the remaining part of the investigation. Considering all aspects, the petitioner is allowed on bail of rupees 30,000 with a suitable surety of like amount to the satisfaction of the Nolbari.
Yes, Lordship.
Huh?
SDGM, Lord, Nolbari.
SDGM?
SDGM.
SDGM Nolbari. Are you sure SDGM?
Yes, Lordship. It was produced before the SDGM board.
To the satisfaction of the learned SDGM S, no?
Yes, Lordship.
Sodor?
Yes,
Learned
Lordship.
SDGM S Nolbari under the condition that the petitioner shall refrain from such activities with which is alleged. The petitioner shall appear before the IO on every fortnight till completion of investigation. Local resident.
Yes, Lordship.
And the petitioner shall not leave the jurisdiction of the court without prior permission. On breach of any of the bail conditions, the court is at liberty to immediately cancel the bail granted to the petitioner, send back the CD.
Only on the ground that main accused Subhas Das not yet arrested. Main accused.
আকৌ এটা লিখি দিয়াচোন learned additional PP has also raised objection as the main accused Subhas Das is yet to be arrested. Objection লগত এনেকে লগাই
May I please, Your Lordship? My Lord, the accused petitioner was arrested on 7/4/2025 and he is behind bar, my Lord, till date 42 days in custody. Allegation is that the intermediate quantity of ganja
Case diary not yet received, my lord, 35.
My Lord, here my bail grounds of bail application is that, my Lord, that's the non-compliance of section 50 of the NDPS Act.
We'll get to know about it only through the case diary.
My here the thing is that, my Lord, the statement made by the informant in the FIR.
We'll wait for the case diary. Next day, if it doesn't come, we will grant you
My
bail.
Lord, may I pray on 23rd, my Lord?
Okay. CDS call for is not received. Issue reminder. List the matter on 23rd.
My Lord. Highly obliged.
Fine, 23rd.
23rd.
Hearing day nahi.
Friday, my Lord.
23rd, yes.
Highly obliged.
Item 36.
36 also, my lord, case diary not received. My lord.
I am an interim lordship.
CDS call for is not received. Issue reminder. List the matter on. Interim orders are remaining still then.
Item 38.
Yeah, please, Lordship. Lordship, as per order dated Lordship, 17/3/2025 Lordship, the petitioners were granted interim protection Lordship, and after getting
You
the
have the
interim,
CD?
Well, yes, my item number 28 and 38, 28 time. 2 p.m. Well, this matter may also
At 2 p.m.
can have at 2 p.m.
obliged.
Item 39.
39 for the time being, my lord. MP Gusau.
For the time being, MP Goswami will be here.
May I plead your lordship?
Just a moment, just a moment. MP, let MP Goswami come.
42, my lord, case diary.
42 অহা নাই কোনো। CDS call for is not received. The petitioner is also not represented. List the matter on 30 May.
Item 43.
My lord, the petitioner
We have the CD?
Yes, yes.
petitioner was granted interim
Shall I
protection.
bring shall I bring the CD? No? It is there.
Yes. Yes.
Lordship, the petitioner was granted interim protection. Lordship, pursuant to that, he has appeared before the investigating authority. Lordship, the earlier also the petitioner approached this honorable court. I have annexed that order at page 36, Lordship. That, but in the meantime, the search sheet in the case was laid, Lordship. And on the basis of the submission made from the CBI, The earlier petition was closed, Lordship, finding no material against the petitioner in the charge sheet. But subsequently, he has been issued notice for appearing before the investigating authority, and thereafter apprehending arrest, the petitioner was pleased to approach this honorable court, and your Lordship was pleased to grant interim protection. Pursuant to that, he has appeared, Lordship, and he is cooperating now.
Okay, may I please, Your
Yes,
Lordship? Paragraph number 5 will speak that he has earlier also filed an anticipatory bail. That was disposed of. No protection has been granted because his name is not reflected in the charge sheet. However, there are number of deposits in the name of different person, and the charge sheet has already been filed. Of course, his name is not reflected therein. But for further investigation, as leave has already been taken in the charge sheet for filing of supplementary charge sheet, for that purpose, time to time, IO used to investigate. So for that event, no AB is required. Unnecessary, this application has come up. In fact, he is supposed to cooperate with the investigating agency as and when the notice has been issued. Nobody is harassing him. And earlier also one anticipatory bail has been disposed of only on the ground that his name is not reflected in the charge sheet. But he is also having the needy scheme. So for that purpose, definitely IO will call him time to time. Mere calling a person for investigating purpose doesn't mean that he will be protected or any anticipatory bail is required. Mere apprehension.
Are there any materials in the case diary?
Some materials are there, some deposits are there. There are different deposits. It is in the part fact.
Lordship, what happens, I have been instructed in the record also, there were two companies are named, but none of the petitioner is not connected with any of the companies, Lordship. So his apprehension is only there because his name figures in the FIR. Subsequent to that, they have filed a search sheet saying that it is a part search sheet keeping a leave open.
Yes,
But,
that leave is always been taken.
Madam,
in that.
I may be allowed to submit. Subsequent to that, he has been issued notice. Definitely, Lordship, all the offenses are up to 7 years of punishment. Some of are more up to 10 years. So definitely, or surely he has got some apprehension of arrest if he is appearing before the IO, Lordship. And that's why the interim protection was given. And the conditions imposed on him in the interim protection while getting the interim protection was not violated till today. He is cooperating, Lordship. I don't think there is any adverse report from the IO. He will keep on cooperating, Lordship. If the investigation may go on, Lordship. There may not be any materials against because in the earlier search sheet while laying the search sheet, there was a specific submission from the CBI itself that there was no material in connection with the present petitioner, Lordship. On the basis of that, the earlier application was closed.
High Court order is also annexed herein at page number 36.
That was
Annexed
closed,
A.
Lordship. That was not rejected.
It is not required at all.
No, it is required, Lordship. I have got the apprehension because all the offenses are non-bailable, Lordship. I'll cooperate, Lordship. All the offenses are up to 7 years. The principle of Ernest Kumar and Satyendra Kumar until will be applicable, Lordship. Routine arrest is not required, but subject to the protection by Lordship.
These are anti-corruption matter and the IO has to investigate time to time. Being a citizen, he is supposed to cooperate. Why time and again he will go for anticipatory bail?
We are not coming time.
The IO, there is no problem as such.
Is the director?
No, Lordship. No, Lordship. As per my instruction, he has no connection with any of the companies.
It is not related with a special crime. It is a mere anti-corruption matter.
While giving him protection, Lordship will have to kindly consider that whether he is cooperating, Lordship. He is cooperating, Lordship. He is not influencing any of the witnesses.
What is his name? Habibullah Mia.
Habibullah Mia.
Just sit down. I'll just check the CD.
Lordship.
Much. Okay, I think can be granted, can be made absolute, I think. To 27/3/2025 order to paragraph 1. Your name?
Manorama Kumari, M Kumari.
M Kumari likhiba de RK Dev Chaudhary jaga M Kumari likhiba. Standing counsel CBI. Paragraph 2. Paragraph 3. Paragraph 1, 2, 3 likhiba tapos baki hin nalage. I have considered the submissions at the bar with circumspection. I have also scrutinized the case diary. The petitioner has appeared before the IO and he has cooperated with the investigation. The petitioner has not violated bail conditions. It appears that, in view of the foregoing discussions, the interim order dated 27/3/2025 is hereby made absolute under the same terms and conditions. So you again appear
Yes.
within 1 week.
It may be 10 days, Lordship. He's residing, no, he's not a resident of Guwahati. It may be 10.
Then I will have to write another long order. You
Let's
appear
in
before
10
1 week.
Lordship. 1 week, Lordship.
Send back the CD.
I'm over.
This matter may be adjourned for the day.
Learned Counsel, Miss, do you have the CD?
Yes.
Miss, what is your name?
S. Musahari, my lord.
As Musahari on behalf of Learned Counsel, Mr.
S. Datta.
Oh, no, your name is there. It's okay. Or Miss S. Musahari has prayed for adjournment. CD is received. CD to be retained till. Are you on interim bail?
No, no. Interim is not. Obliged.
Item 45.
Please, Lordship.
CD
In terms
is
of-
lordship.
in
CD
terms of what?
receipt, he appeared lordship. Interim was there.
Appeared.
Statement recorded lordship.
What is your name?
R. Hawk.
R?
R. Hawk.
Oh, R Hawk. Oh, ঠিক আছে. R Hawk লিখি দিবা। আৰু হেৰি PP এন্ডাস লিখি দিবা 1 2 3 order dated 28/3/2025 4 I have considered the submissions at the bar with circumspection. I have also scrutinized the case diary. I go to scrutinize the case diary likhi diba. I have also scrutinized the case diary. The petitioner has appeared before the IO and he has cooperated with the investigation. Considering all aspects, the interim order dated 28/3/2025 is hereby made absolute under the same terms and conditions. Send back the CD.
No.
Obliged.
CD not received lordship.
Lord, this is second time, my lord.
Interim is there lordship.
No interim.
Oh, no interim.
Short date?
Short date.
28, my lord.
And what about service of notice on respondent number 2?
Service
report,
box
we
is
have
there. I have taken steps to the PP office.
Amicus may be appointed.
Amicus may be appointed.
Notice has been served.
Lordship, I have not received the service report.
Okay. Or you'll have to receive to appoint amicus according to the notification.
Okay.
Communicate with the-
Learned Counsel, Mr. A.K. Azad.
My lord, I have one further submission. In this petition, petitioner number 7 and 4. These two petitioners already arrested. Against them, petitioner becomes.
Has, is present for the petitioners and has submitted that the petitioner number 7 and 4. Petitioner number 7 and 4 have already been arrested in connection with this case. and he's not pressing anticipatory bail petition for petitioner number 7 and 4. Service report on respondent number 2 is awaited. You will obtain instructions relating to learned additional PP. Mr. N. Das will obtain instructions relating to service of notice to respondent number 2. CDS call for is not received. Issue reminder. Is the matter on 30 May?
28 Melody.
28 May.
No.
Pending item 32. May visual lordship is a commercial quantity, but basically only single ground lordship. There, the ground of arrest not mentioned in arrest memo as well as 47 lordship.
How many days?
Days lordship 314 days.
What is the contraband?
Contraband lordship which is 685 grams of heroin and 29 400
340 days. 314
14
days. Okay.
Lord.
Commercial quantity. How many?
Commercial quantity.
600 grams of heroin.
685.65 grams of heroin and Yaba tablets.
85.60.
685.65 grams.
Grams of heroin.
Lordship and Yaba tablets. Lordship.
How many Yaba tablets?
The total 29,400.
Yaba tablets.
But my fundamental rights are
Only the not only merit of the case lordship, because of the notice lordship that I have annexed lordship.
29,000. How many tablets?
29,400 lordship. I'm not on the merit of the case law, only on the arrest memo lordship and the 47 notice where no grounds of arrest has been mentioned. Lordship. That lordship will find on page, it start from page 25 lordship.
Grounds of arrest.
Lordship.
What is
Only
page 25?
25 is the arrest memo where no grounds of arrest has been mentioned. And page 27 is the 47 BNSS lordship where no grounds of notice has been issued.
Anything else? Yes.
Here, my lord, also will find from the vehicle. Both these petitioners are in a vehicle when the seizure took place.
So this is sub judice, no?
All concept position.
Naka checking that.
No, Naka checking.
It is sub judice in the Supreme Court.
Even then, lordship that this honorable court lordship in earlier cases.
Yes,
lordship
yes,
has,
granted, yes.
Bail lordship only on that lordship ground. Otherwise, in merit lordship, it is not a case of granting bail. So it is early.
Commercial quantity, my lord, that is, and your lordship will find my lord 29,400.
That I admit lordship. Not the ground on merit lordship, only the on the ground of notice lordship, which is says, and the most of the persons are granting bail lordship on this ground only.
But this matter is sub judice now. When you are, when the
That hit and run case lordship.
yeah.
That is not still this
When you are apprehended,
that or for trade and
pursued, yes, Naka checking is also attended.
nothing has come out lordship till now, lordship, even CAB as per my knowledge. But this
yes, nothing has come out.
lordship, and most of the people are getting bail lordship. That is only
Yes, it's true.
only single come.
True, but
If it is come out lordship, then it will be ascertained lordship that it is necessary or not lordship.
21 grams of ganja, all these things are okay. 3 years in custody, 21 grams of ganja, but this 1 year in custody, 600 and that too, not only heroin, Yaba tablets also along.
That I admit lordship. I am not arguing on the merit letter.
My lord specifies, my lord, they are peddlers, my lord. Both there. Otherwise, they are not the consumers only. It's clear from the my lord investigation.
Okay, I will have to ponder over it because this is a not a. I'll have to ponder over it. I have to think over it. I'll
No,
pass an
because
order.
in the same situation, similar situation, other persons are granted bail by all the courts, Lordship of this Honorable High Court.
Yes, yes.
They considering the Bihan Kumar, Prabir Purkasto, Lordship, Pankaj
Yes,
Pansal,
yes.
all Lordship.
You
Much
have
more
the
what?
judgments. Give me the judgments. I'll need some authorities. If I just pass an order granting bail on grounds of arrest without any authority in such a heinous offense,
Basically,
it will be
Lordship,
an unreasoned order.
basically, Lordship, Bihan Kumar, Prabir Purkasto, and Pankaj
Yes, give me
Pansal.
the
will
relevant
cover.
paragraphs.
Lordship. Holy Lord, দুটা আছে নে?
You give me the relevant paragraphs.
And regarding the judgment, Lordship will kindly say, I have made a paragraph of citation, Lordship of the
No,
Bihan
no,
Kumar.
no, 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 not others' judgment. You give me the judgment for that original judgments,
Bihan
not
Kumar,
cited in the orders of this court. Yes, original judgments.
Original Bihan Kumar
Ah,
judgment
yes,
you
yes.
want. It will take time, Lordship. I'll bring from
Yes,
my
the original Vian Kumar, Provin Pukasta, and whatever you want to rely on.
Lord.
And the relevant paragraphs.
The relevant paragraph, Lordship, that Lordship will kindly see page 6, Lordship.
In this judgment,
Lordship, in my petition, Lordship. Some part of the judgment has been quoted, Lordship, on page 6 as well as page 7, Lordship.
and then you give me the copies later.
But
You give
today
me the
itself,
copies later.
today itself I'll give, Lordship. I'll get a
Yes,
printout,
yes,
Lordship.
yes.
Want to place one judgment, madam, regarding 1969, 292, madam. Just may kindly go to paragraph 10, madam. There is a constitution and judgment, madam. There some that aspect has also been discussed, madam.
Let me see.
আমার কোটো নেই
One issue Lordship has already pointed out that was pending, madam. That order is there.
Let's make it a little better.
So this case, three-judge bench judgment. This case is three-judge bench judgment. So it will be over the Provibu Castro and
No, but
he has a point.
no, that I understand also. That already been discussed in the regular other earlier courts, Lordship. They have already placed, Lordship. In spite of that, Lordship, these orders were passed, Lordship. They have already shown to other courts.
I'll read the entire judgment and then I'll
Lordship
pass
is
it.
not in continuous in this criminal
This was
offences,
not placed before me.
Lordship. But in other courts, Lordship, they have already put his all these judgment, Lordship. Hearing were there in length, Lordship. It was hard at length, Lordship, in other courts, Lordship.
This is the first time they have placed before me.
Before this court, but other courts already they have placed, Lordship. And the cases were kept reserved also, Lordship, for
A few cases were there. Thereafter, all the cases bail will granted, Lordship. And for last 2, 3.
And in this case also?
Well, all, no, not in this case, Lordship, in other cases, Lordship. Lots of bills were granted, they have.
No, you can just submit orally. You give
No,
me something.
I'll place it at 2 p.m. Lordship, that 3 order, Lordship. That I have got another case is fixed at 2 p.m.
Lima's case,
Lordship.
which has been discussed.
Already
And bail
discussed in
granted.
other
Okay,
cases.
okay, you place those orders. Anything else? Yes.
Much obliged, Your Lord.
Please, Your Lordship, anticipatory bail application, my lord. I'm on interim, my lord. The CD was called for. FIR is from page 14 to 15. FIR is at page 14 to 15, my lord. It's about the sale of a vehicle.
Paragraph 11/4/2025, paragraph 1, paragraph 2, endas, Miss Endas, paragraph 3. Paragraph 4. I have considered the submissions at the bar with circumspection. The petitioner has appeared before the IO and he has cooperated with the investigation. His statement has been recorded. The petitioner has not violated any bail conditions. Considering all aspects, the interim order dated 11/4/2025 is hereby made absolute under the same terms and conditions. Send back the CD.
Deeply obliged.
Pending item 39.
May I please, my lord? Please pair for anticipated bail, my lord. Page 11 FI, my lord. Page 10. Consulate copy, my lord. As, my lord, this FIR, my lord, registered under section, my lord, 65 subsection 1 BNS and read section 6 of the POCSO Act. Allegation is serious in here.
Anybody of order?
Application is dismissed.
Pending item 18.
Lord, here I have received the instruction, Lord. Lord, on the basis of the instruction, Lord, we have also prepared the affidavit. Lord, I need 2-3 days time, Lord, for filing the affidavit in the
My lord.
Well, otherwise the
Date may fix, my lord.
copy of the instruction.
Date. I'll fix the date, not.
This is the instruction I have received.
Learned Counsel Mr. J. Ahmed.
KM Hassan.
KM Hassan is present for the petitioner. Learned Senior Government Advocate Mr. D. Nath is present for the
Respondent, all the respondents.
for the respondents, and has submitted that he has received instructions from the
Deputy Commissioner Morigaon.
Deputy Commissioner Morigaon and has submitted for time to file affidavit along with the instructions. List the matter, full stop, list the matter.
Obliged, my lord.
Item 19.
May I please, Your Lordship. This is a commercial quantity, Lordship. Here I have, Lordship, regarding in this case, Lordship, 2 grounds are there, Lordship. Long incarnation and Lordship, on the other hand, is no ground of arrest was have in the notice, Lordship. These are basically 2 grounds, Lordship. The recovery was 1376.73 grams of heroin, Lordship. from the vehicle, Lordship, which they were traveling. 3 persons were there.
Long incarceration act.
And Lordship, the ground of arrest, there is no ground of arrest in the notice which was served to us, Lordship. And while going to the witnesses, Lordship, there says that section 50 of NDPS Act also not served upon them, Lordship.
50.
50 of NDPS Act, Lordship. That is also not served upon them, Lordship. It reveals from the witnesses itself, Lordship, from the PW1. And basically, they on these 2 ground, Lordship, I have before your Lordship. The long incarnation means, Lordship, today, Lordship, arrested on 3/4/2023. 3/4/2023, they were arrested, and the listed witness are, Lordship, total 11 PWs were there. All are official, Lordship, no independent witness, Lordship. All official witnesses. The vehicle was taken to their office, and thereafter it was, Lordship, the recovery was made before the police, the officers of the DRI, Lordship. All the, if Lordship go to the listed witness, Lordship, Lordship will find all the official, Lordship, no independent witness.
Okay.
And PW, if Lordship go to the PW1, Lordship, that it clearly says in the cross that they have wrongly served the 50 NDPS Act as a custom act, Lordship. The notice was served as a custom act, not as NDPS Act, Lordship. Basically, these 3 grounds, Lordship, are before your Lordship. And the, now we are more than 2 years, Lordship. The trial is yet to be completed, Lordship. Because all are their departments, Lordship, officers who
How
are,
many witnesses are enlisted?
Lordship, 8 are examined till date.
8 examined.
8 examined.
9 examined, only
No,
2
Lordship.
witnesses.
Lordship.
Left.
And in notice part also there, Lordship, we have filed a additional affidavit, Lordship, and they have filed a, Lordship, objection to the petition, Lordship, that basically the FIR, contents of the FIR as well as the final report, Lordship. This is the their condition. Affidavit from Guru.
Nothing about notice in the objection.
Or notice, Lordship, or notice.
Okay. Yes. Mr. Kaya.
Lordship, here, first point, Lordship, out of 11 witness, 9 has been examined. And 2 hours remaining, Lordship, someone has been issued, probably in next date they will be completed. Regarding Lordship, non-service of ground of arrest, Lordship, please to see the additional affidavit. He was arrested on 3/4/2023. At the relevant time, it was not mandatory to serve the ground of arrest.
There is a judgment relating to prospective.
Yes, it's prospective and retrospective.
I don't know, but I heard about a judgment.
Yes, Lordship, that is there. Probably my learned friend has already submitted.
No,
And Consul's case was of October 2023. And Lordship, it goes by section 47.
Arrested on 3/4.
3/4/23.
The mandate of Constitution, Lordship.
Notice was not required to be served.
Yes, Lordship.
So it is a mandate of Constitution, Lordship.
Lordship, please to see
It cannot be said that it is not
No,
mandatory, Lordship. It is a mandatory of the Constitution, Lordship. From the from the date of Constitution, Lordship.
Lordship, please to see what is the language of Article 22(2).
Okay.
Article 22, protection against arrest and detention in certain cases. 1. No person who is arrested shall be detained in custody without being informed as soon as he is may be informed, Lordship. The word inform is mentioned here, Lordship. And he was informed as per page 72. See page 72. It's a notice under section 50 CRPC. In exercise of power conferred under section subsection 1 of section 50 CRPC, I hereby inform you that during the investigation of DRI, case number so and so, dated so and so, you are found involved in and arrested in connection with the above mentioned case. Reference on 3/4/23. So you are forwarded to the honorable court. You may.
Page 72.
Page 72. Additional affidavit filed by my learned friend.
Ah.
They have annexed,
Page 72 in the additional affidavit.
yes, Lord.
But your objection also has a page 72.
No, Lordship, probably there is some mistake, Lordship. Lordship, they filed subsequently, Lordship. The additional affidavit was filed after our application.
Okay. Yes, I got it.
Lordship will see in the what is mentioned in Article 22. It is stated that being informed as soon as may be. And on the same day, he was informed about his arrest.
Yeah.
Under which section, so compliance of Article 22 is there, Lordship. And
NDPS, I think this is how much that you have received also
yes, his
signed in
signature,
English.
his signature
No,
is
no,
there.
ground
How
of arrest,
much you want to understand?
no, ground of arrest is not
A is
specifically
equal to
mentioned,
F,
Lordship.
B is equal to boy.
But in the
How much
Bihan
more
Kumar
to
Lordship,
understand?
it says Lordship, the 19(1) of the Lordship, there is a requirement to inform the arrestee of the grounds of arrest, Lordship. That is the part, Lordship.
Involved in NDPS Act.
No, that
Yes.
is not specifically,
There is grounds of arrest according to.
then let it be on, Lordship, on this Thursday, Lordship.
Why?
For further, Lordship will place some judgment, Lordship. Let me on, Lordship,
All right then.
on Thursday, Lordship.
Learned Counsel, Mr. S. Muni has prayed for adjournment. Learned Standing Counsel, Mr. S. C. Kayal is present for the DRI or NCB?
DRI, Lordship.
DRI.
Or DRI. Please the matter on Thursday.
Ek minute. Regarding that item 32, Lordship, that they have placed the Liam the order, Lordship, that has been clearly discussed, Lordship, in the coordinate bench, Lordship, where at the time of hearing, they have placed that Liam order, Lordship, and that has been discussed in this order, Lordship, and there are around 40 to 50 cases has been granted bail, Lordship, considering the same. Lord, that argument already.
I don't think here everything is there. I don't think.
No, not in this case, Lordship, item 32, Lordship. I was supposed to furnish some judgment, Lordship. For 32, Lordship.
You are talking about another case.
Oh, yes, Lordship, that prior to Lordship break, Lordship, one case
Yes,
was there,
yes.
item 32.
Yes.
Lordship asked me to produce the judgment, copy of judgment, Lordship.
Yes, yes.
That is the case.
He has given me the judgments.
Lordship, the main, Lordship has sought the Probi Pulkasta, Pankaj Bansal, Arvata, no, Arvata. Bihan Kumar, Lordship.
Itu argument to লিখি থৈ দিয়াচোন। ৰাখি থৈ দিয়া ইয়াত মাৰি।
That regarding their place of Modul EMI, Lordship, that is
Modul EMI.
clearly, there is clearly
Modul discussed there.
discussed here,
Okay,
Lordship.
I'll check it.
Lordship, clearly discussed, they have argument that was made in a series, Lordship, it was CAB, then thereafter
I'll
judgment has
check
been
it. You please underline the module EMI.
Lordship, that I have given, Lordship, that paragraph 15, Lord.
You please highlight and underline your relevant paragraphs.
Lordship, much obliged.
I just regarding that, my lord. But after that, my lord, again it was been, my lord, observed regarding that has been discussed in
BA
double 100.
Okay, give it to me.
Yeah, I have given
Itu public prosecutor বুলি লিখি দিবা বেলেগকে। এখানে public prosecutor বুলি লিখি দিবা এখেতৰটো। আৰু এখেতৰটো এখেতৰ নামটো লিখি দিলে হৈ যাব।
Maths review, Lordship. Here in this case, Lordship, the petitioner is in custody since 62 days as on today, Lordship.
Both cases.
28, no?
28, 38, both cases.
Yes.
In item 28, I am appearing, Lordship.
28 to there.
28 is BA and 38 is my lord AB.
ABO.
And present petitioner, my lord, earlier also appeared, his name is also so.
He is also a petitioner in AB also, my lord.
Ah.
In this case, in that case, my lord, he was granted, he was not granted interim at that point of time, my lord. Other petitioners were.
That he
Yes.
was arrested.
And thereafter, on the same day, he was arrested on.
Okay. So how many days he is behind bars?
62 days.
62 days.
So here in this case, my first submission is that Lordship will see page 56, that notice which was given to him, that no grounds is mentioned there.
Otherwise, in this case, the persons who are, my lord, in interim bail, my lord, they appeared statement recorded. And regarding other person, my lord, BA, he was already 62 days, only on the ground of length.
Where is the FIR?
FIR page 10.
We have the CD,
CD receivement.
page 10.
And Lordship also earlier,
Grounds of arrest is there.
and accused number 4 is the father of the informant in the present case.
Accused number 4.
4. He is granted bail by your Lordship earlier.
Informant's father.
Informant is the son, my lord. The father is one of the accused. No,
Accused number 4.
Because father may be taking sides with his brother.
No, actually, Lordship, he wanted to sell some plot of land of his own. And the son who is living with his mother separately, he intervened in the matter and thereafter he lost the petition. So that is the land dispute. Because of that, the petition.
There was assault.
That
What are the
allegation
injuries sustained that there was assault?
Yes, injury report is there, but final injury report is not available in the case diary, but injury is there regarding one, my lord, Sahar Bhanu, laceration of her, my lord, peritoneal region 6 cm into 0.5 cm into 0.1 cm. So injury is there, my lord. Laceration is there. Yes.
But opinion is not.
Thereafter, my lord, petition referred to FAMC, my lord, final report not yet received.
Opinion is not given. That Sahar Banu,
Yes.
she has she mentioned who has dealt the
Yes.
head blow?
Yes, my lord. By the present petitioner, my lord, Amez Ali, my lord. Amir Ali. Earlier, your lordship has not granted interim to that accused, my lord. Later on, he was on the same day he was arrested.
Okay. That's the reason maybe I didn't.
Yes, ma'am.
All right. Our learned counsel, Mr. A. Ahmed, for the petitioner, Amir Ali, alias Amir Ali, who has filed this application under section 483 of the BN, SS 2023 with prayer for bail as is behind bars since 18/3/2025 in connection with so-and-so PS case under so-and-so sections. Heard Mr. MP Goswami, learned additional PP Assam. Full stop. The allegation against the petitioner is that the petitioner, along with other accused named in the FIR, assaulted the informant and his mother, Sahar Bhanu, and his wife. It is submitted that Sahar Bhanu has sustained injuries on her head, and the opinion relating to the gravity of the injury is awaited. Learned PP has raised objection, okay?
Yes,
Stating that they are
considering the
in this
injury.
case against the present petitioner. Learned counsel for the petitioner has submitted that the informant has also arraigned his own father as an accused in connection with this case. Most of this is a matter of family dispute relating to land. To stop. The petitioner has been behind bars and his further custodial detention is not required for the progress of investigation. I have considered the submissions at the bar with circumspection. The petitioner has been behind bars for 62 days. No? 62 days. It appears that further custodial detention may not be required for the progress of investigation. Considering all aspects, the petitioner is enlarged on bail of rupees 50,000 with a suitable surety of like amount to the satisfaction of the
Chief Judicial Magistrate Nalbari.
Nalbari under the condition that the petitioner shall refrain from such activities with which he is alleged. Number two, the petitioner shall appear before the IO on every fortnight till completion of investigation, and the petitioner shall not exercise threats to witnesses or try to influence them. Send back the CD.
Problem, Your Lordship.
Same case, no?
38, my lord, this is AB, my lord. Earlier, the present petitioner is also one of the party in this petition, my lord, AB. And on earlier, your lordship has granted interim on 18/3/25. Thereafter, petitioner number was arrested, my lord, in item number.
Petition number 4 to nilikiba, baki kini likiba.
We appeared before the IO. I am in lordship.
Appeared statement.
I am in
Lordship.
for the petitioners 1, 2, and 3. Petition number 4 to nala they are arrested. Itu 17 order dated 17/3/2025. Paragraph 1, khali 1 to 3 na 4 to nilikiba. Aru lana additional PP Mr. P Botharu likhi diba. Our prosecutor naam ase etu nalage. Paragraph 2, paragraph 3. Interim to nilikiba khali paragraph 3 interim word to ase hetu nilikiba. Pre-arrest likhi diba interim jagat paragraph 3 last line pre-arrest period. Considering the submissions of the bar, the interim order dated 17/3/2025 is hereby made absolute under the same terms and conditions. Send back the CD.
Highly aware.
May I please, Your Honor? Your Honor, I'm really engaged in this matter, Your Honor. I have submitted my wakalatnama allowing the NOC of the earlier council, Your Honor. In this matter, on earlier 3 occasions, Your Honor, case diary was called, but no case diary was received, Your Honor.
Okay, we'll call them.
Your Honor,
We'll call it CD.
Your Honor,
Any short date, my lord, I will get it, my lord.
Yes.
Your Honor, the allegations,
CD as call for is not received. We should reminder list the matter on.
Your Honor, I have a prayer to make, Your Honor. I have prayer to make.
No.
Oh.
Earlier you didn't apply, make any prayer for interim bail. Today you didn't apply.
Your Honor,
Thereafter you didn't make any prayer for interim bail. Not now.
Your Honor,
Not
I have
on
a
the
prayer for
30th.
interim bail, Your
Call
Honor.
for the CD along with the injury report. If any, list the matter on.
You know, kindly, Your Honor, interim may be allowed.
When?
27.
Interim may be allowed, Your Honor.
Huh?
Interim may be allowed, Your Honor.
Go ahead.
Okay, place your submission. Just a moment. Place your submission.
Your Honor,
On what grounds?
if you go the FIR, Your Honor, the whole FIR is a concorded one, Your Honor. Everything is falsely concorded out
On
here,
the
Your Honor.
on the same petition you are stating.
Yes, Your Honor, for the same petition.
Where have you, in which paragraph you have mentioned that the FIR is concocted?
Actually, Your Honor, I haven't drafted the petition, Your Honor, the earlier.
Then why don't make.
My lord,
oral
this is
submissions?
regarding item number 50.
Your Honor.
IO has-
Don't make oral submission just here and there.
Over the 27, I was wondering. Short date, my lord.
IO has also asked for a date. Let us call for the city short date.
Yes,
Yes, sir.
27. No, from the 27. In this
May I
case,
please,
we
Lord-
file our objection that requisition was sent to the section Lord, but
You want to file objection?
no, already filed. We,
We have received a copy of the petition, Lordship.
but in record it is not available.
So for the item 55 is concerned, they both are the same, out of same transaction. In that case, a scan copy is also received, your lordship. That may be gone through, your lordship. And the
Oh, no, without the objection, we cannot take the submission. They have filed objection. They have not sent today. I think that objection you have placed today, no? Okay. So we'll fix it day after tomorrow. Tomorrow we won't have time because now if I pass the order, when will they place the
lordship, may I
day
please,
after tomorrow?
may I please, lordship, yeah. Already the case has been granted bail.
This is a NDPS.
NDPS, a commercial amount was here, and the long incarceration,
What?
pardon,
Yes.
What is the amount? What is the amount?
411 kgs of ganjas,
ganja.
ganjas. And the long
How
incarceration
much
is
they have been behind bars?
4 years, 1 month and 10 days today. It already has been.
Quite a
completed.
long time.
So that may be considered and a
No,
person.
no. See, you will file a petition, we will consider your petition. They will file an objection. Why should I not consider
Right,
the
right. I
objection?
can understand, but
Tomorrow.
Tomorrow. The objection submitted, duita ke sab likhi diyo. The objection submit, as it is, I will not pass any order today. That is why, as it is, I would have.
in the other case,
I don't
they,
have time.
pardon, yes.
I see, tomorrow, I think I have time. If it comes tomorrow, maybe I can pass the order immediately tomorrow. But today, I may fix it for delivery of date because I'm overloaded already. I have many
Already
orders.
maybe
to
tomorrow,
pass,
but
several orders to pass.
my prayer is there. Another item is there, item 55 and 54. In both cases, they have not filed a objection. It should not be that tomorrow again they will ask for the time. Only one, in one case, they have filed.
In 54, we have filed. In 55, today we are filing.
54, 55.
Whatever the objection they.
54, 55, list the matter tomorrow, register to place the objection in the record. 55 of Nikki, vote no.
54.
And the copy be served to the person.
And
We'll submit.
place the objection on record tomorrow, date to people. Tomorrow, Kali, 20 tarik na 20.
Much of. It will take.
For order. तुमको कॉपी डिलीवरी बोले ठीक है लिखा ना नंबर आए
Yes, your lordship, may I please your lordship?
हाँ
Your lordship, the applicants are the
Rohingya
Chin refugees, your lordship.
हाँ
Chin refugees, basically they are the citizens of Myanmar, your lordship, who has been illegally entered into India in the year 2021 and after, and subsequently they have been arrested and a judgment was pronounced against them in the year 2022, your lordship. And since they are completed, your lordship. At
they have
present-
completed their conviction.
Yes, your lordship, way back, your
So
lordship.
now they want to go back.
Not to their country of origin, your lordship.
But who are giving them this what it is called?
A refugee certificate, your
yes.
lordship, that has been issued to all the applicants here in your lordship. That has been issued by the UNHCR, your lordship. And at present, a discussion, communication on the deportation or the transition to the third country is going on, your lordship, with the applicants, with the UNHCR, lordship. And our humble prayer is only to that extent, your lordship, till that discussion, at least we should not be pushed back or deported to our country of our origin, your lordship. As many.
Where do you stay?
At
Yes,
Matia,
yes.
at Matia, your lordship, at present,
Matia.
Matia, your lordship.
Yes.
Interviews are going on. Even it's
Lordship will appreciate. They are foreign nationals. They have been convicted after completion of their sentence. Since there are restrictions on illegal foreigners who have come to the country on their movement, they are kept in the Matia Detention Center, and that is as per the notifications issued by the MHA from time to time. And insofar as the UNHCR is concerned, Lordship will also appreciate that India is not a signatory to the UNHCR.
Yes.
We do not recognize any refugee card issued by the UNHCR. So far as their deportation is concerned, I do not have any material whether they are immediately going to be deported or not. At best, Lordship will give me an opportunity to respond to this IA. If at all there is anything, because we would not like to have them here. This is not a ground that everybody will come and stay here. You have come through a wrong channel. Our duty is to push you back to your native state. But if they are willing to go to some other country, that's up to them. But at this moment, Lordship will give us an opportunity. I'll get the instructions. What is the present status? And that is all.
All right, let them get instructions.
Till then means deportation process.
That
At least
they are not citizen of India. We
Yeah,
cannot
we are
keep
not
them here.
claiming that we are citizen of India. We have stated also in our
Yes, yes,
petition.
yes.
We are not stating, and we also want to leave
Lordship-
this country, Lordship.
Lordship will-
We don't want to stay in this country, Lordship.
So then why
Even
did
it's
you come for in the first place?
because of our life. Life is
yes.
important, Lordship. Because of our life threat in our own country, this is the reason we have to save our life. And infant children is there, Lordship. A 2-year-old child is there. Where parents will go because of life threat only they have
Lordship
to
will-
escape.
If you have finished, madam.
Yes, Lordship.
Lordship will give me 2 weeks time. I'll get the instructions. In 2 weeks, nothing is going to happen.
In 2 weeks, I think so. I
In 2
don't
weeks,
think,
nothing is going to.
within
If
2 weeks
anything,
he'll be
if there is anything, Lordship, she will make a mention. I'll cooperate with the court.
Yes,
Yes, if my senior friend gives the undertaking
Because-
that nothing will happen to them, then no
Because
issues, Lordship.
this-
Without interim order also.
This has become
Take it,
a
yeah.
ground where everybody will come, stay and eat on us. No, that is not done.
They also don't want to stay. I am in my petition also I have
So
stated.
What, from which nation?
They are from Myanmar, Lordship.
Myanmar,
Yes,
but they are not Rohingyas, no?
No, they are not. They are Christian.
Christians.
They are Christians. They are Chin refugees, Lordship. They're
Persecuted.
from the state of Chin and country is Myanmar, Lordship.
All these are persecuted in.
Yes, Lordship. And
They are-
conviction
they are-
also is over.
They are persecuted, but they do not fall under the definition under the our
There are some countries like Germany, I think, is one of the countries maybe.
like there are places like Canada most probably they are going to Canada because it's half empty.
Yes,
It's
last
bet-
year.
It's better they go to Canada. than in
Last
India.
year, to UNHCR, with the help of UNHCR, last year, November, December, 500 were being
And
resettled in third
Canada.
country.
I don't know how this institution is functioning in India. When we don't recognize, how can they issue cards and do all this? Anyway, no, we fix it after 2 weeks.
For learned counsel, Ms. D. Ghosh, for the petitioner, and learned government advocate or
Deputy SGI, Lordship. Deputy SGI.
Deputy, okay. Deputy SGI for Mr. Arkesh D. Chaudhary for the respondents who has submitted for time to obtain instructions
Yes, Lordship.
and place objection? No.
Objection if any, Lordship.
Obtain instructions and place objection if any, list the matter on. It's a period detail.
I'm for 1 and 5, Lordship.
Okay, respondent number 1 and 5. And learned
That's
counsel,
will be my state.
A go for. Respondent number 2, 3, and 4.
2, 3, 4, and 6, I suppose.
2, 3, 4, and
I
6.
think specifically.
You are government advocate? Or on behalf of government advocate? Government advocate. Government advocate. Do have the video data video?
That's fine, Lordship.
Deeply.